Welcome. The Jordan Schnitzer Museum of Art and the Law School are pleased to present a panel discussion today entitled Land, Law, and Liberty, Legal Perspectives on Tribal Rights. We've got three excellent panelists that will discuss the issues. And I'll introduce each of them in a minute, and then we can begin the program, and each of the panelists can speak, and hopefully we'll reserve a bit of time for questions at the end. I think there's a class coming in at probably a little bit before 1:30. This panel discussion is one of the programs that the museum has arranged in connection with the retrospective exhibit that will be opening tomorrow that celebrates the works of Rick Bartow, a prominent Native American artist. And the exhibition will be on from tomorrow evening to August 18th. And there's a special public...
August 9th.
Okay, 9th. And Rick will be, the public reception will be tomorrow evening at 5:30. You're all welcome to come. There'll be lots of interesting events occurring, including Rick Bartow will be playing with his band. On your extreme right is Congresswoman Elizabeth Furse. She has a long and distinguished career of public interest work and service. In earlier years, Congresswoman Furse became involved in an LA women's self-help project in Watts, and later with Cesar Chavez's United Farm Workers movement. In 1966, she became involved in Native American rights, including fishing and tribal rights. Congresswoman Furse is a graduate of Evergreen State College, and moving to Seattle, she became involved in the tribal fishing rights struggle. She co-founded Citizens for Indian Rights to educate people on the legal issues surrounding Indian treaties. Citizens for Indian Rights grew into the National Coalition to support Indian treaties. In 1950, she became the restoration coordinator for several Oregon-based Native American tribes seeking federal recognition. She and others successfully lobbied Congress to grant federal recognition to the Coquille, Klamath, and Grand Ronde tribes. Between 1980 and 86, 4 restoration acts were passed to restore 5 of Oregon's terminated tribes. She was elected to Congress in 1992 and served admirably for 3 terms. After retiring from Congress in 1999, she was a professor and director of the Institute for Tribal Government at Portland State University. On your extreme left is Jason Younker, who will speak second. He's a graduate from the U of O in 2003 with a PhD in anthropology. Jason is the Assistant Vice President and Advisor to the President for Sovereignty and Government-to-Government Relations. He is a member of the Coquille Indian tribe and grew up in Coos Bay, Oregon. And then in the middle is Howard Arnett. Professor Arnett received his BA from Stanford, a Master's of Science in International Relations from the London School of Economics, and a law degree from Oregon Law in 1977. He is a partner in a Bend law firm where his practice for the past 35 years has focused on representation of tribal governments in the Pacific Northwest, in particular the Confederated Tribes of the Warm Springs Reservation of Oregon. Professor Arnett is an adjunct professor at Oregon, teaching 4 different courses related to Indian law. He's active in the Oregon State Bar Affairs. He was recently appointed as president of the Oregon Law Foundation Board for 2013, or he was for 2013, and currently serves as the statewide co-chair of the Lawyers Campaign for Equal Justice. In addition, he is a past member of the law school's Dean's Advisory Council. Welcome. Maybe if Elizabeth, you would start us off?
Sure. The first thing is a test. How do you know when a congresswoman is retired? She wears jeans. I came to this work through, I've been in civil rights all my life, South Africa, anti-apartheid movement, the things that you heard earlier. But I came to this work because I met a man on the river, a great man named Billy Frank, an Nisqually Indian man. He had just come out of prison that morning. He was arrested 52 times by the federal government and Washington State for fishing under treaty rights. And so I became involved, went down to meet him. And I want to just say to you law students, the people who might go into Indian law, it's great to learn about federal Indian law in the law school, but I want to urge you to go see the people who are living the law every single day. Fishers on the rivers, tribal governments. We really can't talk about Indian law unless we know tribal folks, and I just want to urge you to do that. As a member of Congress, I want to say most acts of Congress start because somebody comes to you with a problem. Somebody says, is there a piece of legislation we can get that will fix the problem? That is not so the way the Congress deals with tribal governments, as Howie very, very well knows. Article 1 of the United States Constitution says that Congress shall have the power over trade with tribes. As all jurisdictions, Congress immediately started to expand that power. Trade, now they think they have power over everything that Indian governments do. So there's an expansion of that First Amendment, article. There's another article in the United States Constitution, Article 6. Article 6 says, treaties are the supreme law of the land, and all judges are to be bound by them, state law notwithstanding. Now, when you're a member of Congress, you take, when you're a city council person, but a member of Congress takes an oath to uphold the Constitution. And I would say to you, with no disrespect, that perhaps 2% of members of Congress have any idea about the issues of federal government, of tribes. And yet they happily take this oath, and then they start passing legislation. Now, does a tribe come to them and say, we think there's a problem? Virtually no. I have a list of the acts of Congress, and you'll see a real change in time from 1871 treaty making, 1865 out here. Then we have the removal. That's moving tribes off their land. Then the General Allotment Act, 1887, where the United States government decided that despite these treaties that say that this land that the tribe reserved is their homeland, despite those, the United States Congress decides to allot land on the reservation. That means they gave certain people 80 acres, the tribe gets a certain amount of acreage, and then, surprise, surprise, after it's all been allotted, the excess is open for non-Indian ownership. Now, the treaties say, and they are the supreme law of the land. So then we get to all sorts of other lovely things. The Indian Reorganization Act, where Congress thought that they could stabilize land holdings and that the tribes would take on certain constitutions which in no way fit their culture. Well, I suppose the Aztecs, that might have something very hierarchical, but really didn't fit there, but they had to take it. Or most of them did. 77 tribes refused. And then we get to the really fun time with the United States Congress, the 50s. 1953, Congress passes the Termination Acts. Actually, he called it Termination Act was called the Resolution 108. That allowed states really to come forward and say, you know, it's kind of a nuisance having these sovereign governments in the middle of our lands. And so the federal government said, yes, that must have been difficult, and it's also expensive, of course, to keep spending the money on these treaty-guaranteed health care, education, protection from the new settlers. And so they passed the Termination Acts. Oregon was the hardest hit. 63 tribes and bands were terminated in Oregon. What does that mean? Did they all die? No. It ended the relationship between the federal government and the tribe. And as Howie will tell you, as a lawyer for a tribe, that is the most important relationship. That is the government to government, sovereign to sovereign relationship. I believe, I worked on Restoration Acts, I believe that the goal was natural resources. The Klamath tribe had the largest stand of ponderosa pine in the world, and it was all sold to timber companies. Shipped across, tribes no longer had a homeland. They'd always had homes on the reservation, no longer. They, extraordinarily enough, held on to their hunting and fishing rights through an amazing man who was their chairman. Okay, so the Termination Acts. Then there's Public Law 280, where, oops, suddenly we're going to give federal jurisdiction to the states. So the tribes would share their jurisdiction with the states. The Warm Springs tribe, under good management and leadership, and because they had made friends with the Congress, and I'm going to talk about that very briefly, I see we have very little time. The Warm Springs tribe are exempt under the Act from Public Law 280, but they're the only tribe in Oregon that are. So when you drive on the Warm Springs Reservation and you commit a crime, you're pulled over. It could be a tribal policeman or it could be a state patrolman. They have cross-deputization, but on every other reservation, the federal government has given up, in many cases, its jurisdiction or responsibility. The tribe retains it under federal law 280. Okay, so what I want to talk about a little bit, and I'll try and keep it short, is that 99% of Congress people know this much, literally, about federal Indian law. And yet they have passed these terrible acts. Now, come the 70s, everything began to change. The tribe got lawyers. The tribes began to become lawyers themselves. And so now you see acts which are actually beneficial to the tribes. Now, in 1924, a little sort of side, Congress decided that all Indians were citizens. I thought that was kind of charming, isn't it? They've only been here about 15 million years. But anyway, Congress did that. It was sort of a thank you for the work that tribes did during the First World War, because tribal people serve at a higher percentage than any other ethnic group in this country. So 1924 was good, but then came the 70s, and I think this is where Howie was so involved representing this wonderful Warm Springs tribe. The tribes began to know that they had to get to know their own congressional representatives. They couldn't just think, well, we're a sovereign and we don't need to talk to them. And the Warm Springs in particular, I think, developed these relationships. I want to tell you a little story. In 1994, I was elected in 92, sworn in 93. 1994, along came a man from Arizona named J.D. Hayworth. J.D. was as right-wing as anybody could be. But I watched when J.D. came in. Wherever he went, so went the Navajo Nation. They dogged his footsteps. They spent days educating him. And I was always love it when J.D. and I would go to the floor to vote. I mean, we had nothing in common except for tribal issues. They had educated him. They were a big group of voters, and J.D. and I were arm in arm. And that was because the tribe took the time. They didn't send a lobbyist. Everything in the Congress is relational. Everything. When the Native American caucus there's a bad bill on the floor, 5 members, myself included, we would stand at the doors. There are 5 places where the Congress come in. Nobody knows what's in an Indian bill. So we would stand there and say, vote no on this, it's bad for tribes. Bing, they'd vote no. Why? Because they knew who J.D. was, they knew who George Miller was, they knew who I was. They said, oh, well, it's okay, we can do it. That's a terrible way to run a railroad. Terrible, when people's lives, their property depends on this. So if I were to advise a tribe right now, I started the Institute for Tribal Government to do this. If I were to advise a tribe, first of all, I'd say develop the relationships. Secondly, I would say develop an in-house lobbying group. The Umatilla tribe have that. I think it's very helpful, where the council then knows what's going on. They don't go to DC without the background. I taught a class once, and the chairman of Warm Springs said to me, they went to DC and they were handed this huge briefing book, and he said, no, Elizabeth said 1 page. Because you have to get it where people are comfortable. And I know that when the Warm Springs go to Washington, D.C., they're not wasting their time. There's a huge amount of waste of time on this stuff. You've got to be on it every single minute. And as lawyers, you have an incredible chance to make a huge, huge difference. But do it through knowing tribal people. Knowing the Billy Franks who've put their lives on the line every single day. Well, Billy's dead now, but he was our hero. And understand that this is not something that doesn't matter. Every bill in the Congress matters, and particularly matters to tribal people. You have here at this law school one of the most outstanding professors in law, Mary Wood. I wish I'd had her when I was in law school. I might have stayed in law school, not become a politician. I would ask every one of you to read her book. She's so incredible. Thank you for having me in the same place where Mary teaches. I think that's an honor, and I appreciate it.
Thank you. Vice President Younker.
I am thrilled to be here and very pleased that Elizabeth is here too. Because of her, I actually get to call myself Native American. I'm a member of the Coquel Indian tribe, one that was terminated. And before I got old and gray, most of my life I spent as a non-Indian. And now that I'm old, I spend a lot longer now. So I'm pleased that not only DeFazio, but Elizabeth Furse stood up for tribes who really didn't have a way to recover from all of the devastations of termination. I'm going to be very brief. I spent the last 10 years in New York, where you have the Haudenosaunee Nations, the Iroquois Confederacy. And their appreciation for sovereignty is absolutely incredible. And I believe that that's why I lived there for 10 years, even though I was just being a professor. They are the template for our democratic society. Benjamin Franklin came in and said, if those ignorant savages can have a democratic society, certainly 13 colonies who desperately need it can learn how to have a democratic society. And I'm ad-libbing there. But they appreciate democracy at its extreme highest level. Tadadaho, who is the president of the Grand Council, the 50 chiefs from these 6 tribes, will only speak with the governor of the state or the president of the United States. He does not speak to anybody else. He did speak to the president of my university, and it was because the president of the university went to him and said, we need your help serving Native Americans on our campus. Only under those conditions did he come and present himself. And I appreciated that because it was much different than my experience as a Coquel, where we absolutely had nothing until 1988. We met as tribal people, but we didn't have any way of saying we are Coquel. Now, I don't know if I look German, But it's very hard for me to pass as German, even though, the Germans had to live next to the Indians during the World Wars because they were the same class as the Indians. We were always dirty. So the Germans who were out of unpopular had to live with us, and so we intermarried. But I had to say, well, I'm not Indian because I'm German and the government won't allow me. Oregon's native experience was much different than many of the other 566 different tribes across the United States. Colonization was exceptionally swift. It was augmented by horrible, horrible diseases. And it was complicated by a treaty era that didn't see these treaties ratified by Congress. And so when it came time to deal with natives in Oregon, the federal government did not know exactly how to interact with them because there was no treaty that was ratified for many of the tribes that were terminated. Yes, we got to call ourselves citizens in 1924, just in time to pay taxes during the Depression era. I mean, some of these things are still having impacts on us. By 1954, the Coquel had won their case with the federal government saying that, yes, they are Indian, but just in time to get terminated. By 1988, we had finally resolved all of the issues that we could think of and were federally recognized. We were the last tribe to fall under the National Indian Gaming and Regulatory Act. So we are the last tribe that is able to have a casino on our lands, on a reservation is how, or trust properties is how the act generally reads. But the Coquel don't have a reservation. We weren't allowed that because we weren't Indians. We didn't have a treaty. We have what's called a service district. So you have to really understand what termination means to each and every tribe. Grand Ronde were terminated. Klamath were terminated. Siletz were terminated. All of those tribes have reservation lands, but the Coquel, we had to buy our land, put it into trust. And so when we now talk about reservation shopping, and the Coquel say, well, we have membership down in Medford, Oregon, and we have a healthcare facility down there, and we're going to put a casino down there. Everybody gets up in arms about, that's not where they're from. Well, I got to tell you, we were moved all over the place, and we would rather have all of our membership in Coquille or Coos Bay in our Aboriginal territory, and we'd like our 800,000 acres back for all of the promises that we were given under this treaty that was never ratified. There are 3 areas that I could think of off the top of my head where we desperately need advocates, legal advocates. We need people to better understand and educate others about the impacts of termination. Not only the impacts that were immediate, but the ones that we are still experiencing today. Again, Congress has zero idea of what it's like to be terminated and live in fear of being terminated again. Everything the Coquel do today is so that we don't get terminated tomorrow. And we should not have to live through that fear. When a federal government makes a promise, it should be uncompromised, or we don't have diplomacy. How else is the rest of the world going to trust the United States government's word if they can't trust what has happened here in the United States in their backyard? We need more sovereignty studies. Sovereignty is a big, long, fancy word, hard to spell. I always have to hit spell check on it. But it is the only leg that we stand on. And we need people to understand that the strength of sovereignty is a decision made up by non-Indians. It only allows us, you guys are the ones that determine whether or not I get to call myself Native American. You vote in the wrong people. All of a sudden, you'll have termination. The Chinook were a fantastic example of this. This is a very culturally sound tribe up in Washington. One day they were recognized. Then President Bush was elected in, and he began termination proceedings. 1 year later, they were terminated. What makes it really difficult once you're terminated is to get reorganized and federally recognized. So there are now new tribes that are putting together their cases, and they will have a better opportunity of getting federally recognized than, say, the Chinook, who were and then were terminated again. We need people into sovereignty studies. And most importantly, we need advocacy for restoration. We gave up our land for promises, and the reservation shrunk, the promises and treaty provisions never materialized. We desperately need your help. And that's all I have to say.
Very good.
Thank you.
Thanks, Elizabeth. Thanks, Jason. I'm humbled, but being the semi-law professor as an adjunct, I've got to cover a little bit of legal stuff. And thinking about this panel, I was thinking about, well, what makes a tribe a tribe? What does it mean to be an American Indian tribe under American Indian law? So I went to the case book, the textbook we use in my Indian law courses, and there are two professors who opined on this. One is Sarah Krakoff, University of Colorado, who is one of the authors of this textbook, and the other is Carol Goldberg, UCLA, who is a very prominent scholar of Indian law. And they basically see two requirements, both legal and culturally and otherwise, to call a tribe under American Indian law. And Krakoff says that one of those requirements is sovereignty. Sovereignty is the necessary buffer that allows distinct, unique, and endemic cultures to survive. And she's even more emphatic later on. She says, to put it bluntly, without sovereign American Indian tribes, there would be no American Indians. In other words, political sovereignty is a requirement for a tribe to be a tribe, and it's also necessary for Indian people to survive as Indian people, is for them to be part of units that are called tribes that have political sovereignty and can exercise sovereignty. So that's a political component. It's a governmental component. Sovereignty is the power that governments exercise, particularly native governments in the United States. Carol Goldberg adds another requirement. She makes a similar point. She says, very simply, if Indians do not have a protected land base and some substantial measure of self-determination, Indian culture will fade and ultimately disappear. So she says tribes actually have to have two things. One is a political component, a governmental component, sovereignty, where they can exercise political and governmental power, and they have to have territory. They have to have a land base over which they can exercise that governmental power. Those are the two essential elements: sovereignty / governmental power, governments, and land, territory, something to govern, some territory to govern. So I want to talk about what I think are two of the most interesting developments in American Indian law right now, which involve two distinct, very different, but in some ways similar Native American groups, both of which are faced with challenges in establishing that they are truly Native American communities under American Indian law. Those two groups are Native Alaskans and Native Hawaiians. Keep in mind the two requirements that the professors say: you have to have a government exercising sovereign powers, you have to have territory. Now, Native Alaskans and Native Hawaiians both have some things in common. Number one is they're both really large. There are a lot of Native Alaskans and there are a lot of Native Hawaiians, proportionally, especially for their states. No states come close to Alaska and Hawaii in terms of the percentage of the population of those states that are represented by Native people. Alaska has 700+ thousand people, and 25% are native Alaskan. Hawaii has about 1.5 million people, and there are roughly 400,000 native Hawaiians, 2/3 of which live in the state of Hawaii. So that's another high proportion of the state's population represented by native people, and no other state comes close to Hawaii and Alaska in that regard. And it's interesting, too, that the state governments in both those states have taken historically and currently very different positions with respect to their native people. The state of Alaska has an ongoing challenge to the efforts of native tribes and native communities in Alaska to exercise sovereignty, and particularly to exercise authority over territory. The state of Hawaii is supportive of the native Hawaiian groups in their efforts to not only exercise authority over their lands, and they have lands, but also to become governments and exercising sovereign powers. Curiously, another thing they have in common is Chief Justice John Roberts. Both those native groups, Native Alaskans and Native Hawaiians, have experienced setbacks in the U.S. Supreme Court. And in those setbacks, Chief Justice John Roberts, who wasn't Chief Justice at the time, participated. He was an attorney for a party in those proceedings. He was on the winning side in one case and the losing side in the other. For Native Alaskans, the setback was the Village of Venati case versus State of Alaska in 1998 in the U.S. Supreme Court, where the Supreme Court ruled that the native corporation lands established under the Alaska Native Claims Settlement Act of 1971, it's hundreds of thousands of acres in Alaska owned by regional and village corporations, and the tribe, the native village of Venati, Athabascan Indian village north of Fairbanks, made the argument that its village corporation land, which is actually fee land, not trust land as we call it in American Indian law, that constituted Indian country. And it meant that under American law, they could exercise territorial sovereignty and jurisdiction over their Indian country, their village corporation fee land. The Supreme Court said no. And John Roberts represented the state of Alaska. When he was in private practice as a Supreme Court practitioner in Washington, D.C., he had appellate practice, and his little specialty, his niche within a niche, was representing states. And so he was on the winning side and the tribe was on the losing side in that setback for the Alaska Native people. And they're still trying to overcome that setback, and in a minute I'll talk about the promise for the future. There is a way to overcome the setback they experienced in the Supreme Court in the Village of Venati case. For the for the Hawaiian Native people, their setback was in 2000 in the Supreme Court in a case called Rice versus Caetano. And John Roberts represented the state of Hawaii in that case in the Supreme Court, which was the losing side, as it turned out. The state of Hawaii was defending a legal challenge to a statutory scheme under Hawaiian law that provided that for a state agency, the Office of Hawaiian Affairs, which administers the Hawaiian native lands established by Congress in 1920, Hawaiian homelands, this state agency is governed by a board of trustees, and under Hawaiian state law, only Native Hawaiians could vote in the elections for members to that board. And that was challenged under the 15th Amendment grounds by a non-native Hawaiian citizen. The Supreme Court said, well, the problem with Native Hawaiians is they are not a tribe. They do not have a formal tribal trust relationship and government-to-government relationship with the United States government. Therefore, they're not a tribal community with that special relationship, which would change the constitutional analysis about whether this special statute authorizing only certain Hawaiians to vote in these state elections is constitutional. So because the Native Hawaiians, the Supreme Court said, do not have this special relationship, they're essentially not legally a Native community under American law, therefore the statutory scheme fails. So from the standpoint of Native Alaskans, what they have is clearly sovereignty. I'll talk about it in just a second. There was some issue about that in the 70s and early 80s, but that's now been settled. There are 566 federally recognized tribes in the United States at last count. About 234, I think, are in Alaska. Those are Alaska Native villages that have organized governments under the Indian Reorganization Act or some other mechanism, and they are recognized by the federal government as being Indian tribes with sovereign powers, the ability to exercise that one of those two key components. And then Alaska, in Hawaii, the problem is just the opposite. They actually have land trust territory, which could be recognized as their native territory and the area over which they could govern if they could establish a federally recognized relationship with the United States government. And that's their challenge for the future, and there is promise that perhaps that issue is going to be solved going forward. Let me talk a little bit about Alaska. Alaska is complex. Alaska Natives are called natives because they come from different groups. There are at least a half a dozen distinct groups of Alaska Natives. There are Yupik people, Inuit people, Athabascan Indians, Aleut people occupying the Aleutian Island chains and Kodiak Island. In the southeast, in the archipelago, Tlingit and Haida Indian people. And then there's always the asterisk for Alaska, which is Metlakatla. It's the only reservation in Alaska. Everything about Alaska, you always have to say, except for Metlakatla. Metlakatla is a reservation right across from Ketchikan in far southeast Alaska. And the Indian people who occupy that reservation are actually from British Columbia historically, and they were political and religious refugees in the late 19th century to Arnett Islands, and the United States government eventually recognized them as a tribe. And so it's kind of hard to think of the Canadians as oppressors politically and religiously, but apparently there was something happened in the late 19th century that caused these folks to leave BC and immigrate to Alaska, and they're now a federally recognized tribe. So the other thing, several other things that are unique about Alaska. One is there are no treaties with Native Alaskans, and that's in part because Alaska didn't become part of the U.S. until 1868, and treaty making ended in 1871. Congress decided, particularly the House, was jealous of the Senate and their treaty-making power. They passed a law saying no more Indian treaties going forward from 1871 on. So there are no treaties with Alaska Natives. But Indian law and Alaska Native communities continued forward until 1971, pretty much like the rest of the country. There were some allotments in Alaska under the General Allotment Act. There were Indian reservations, established this Village of Venati case that went to the Supreme Court. They had a reservation. But when the Alaska Native Claims Settlement Act was passed by Congress in 1971, that changed everything. It ended all reservations in Alaska. It extinguished all Aboriginal title in Alaska. It ended all native hunting and fishing rights in Alaska, and it created in their place. And this was at a time when Congress was moving sort of out of the termination era that you talked about, Elizabeth, into what's called the self-determination era. So there were kind of aspects of, from a policy standpoint, of both those eras in the Alaska Native Claims Settlement Act. Going forward, it's clear that in Alaska, the governments of those tribes survived, but the land did not. The land all became corporate-owned land by village corporations and regional corporations, all native corporations, but it wasn't considered Indian trust land or Indian country. But now the government is, after losing a lawsuit, considering changing that. There is a statutory authorization for an administrative process called the Fee to Trust process. Under the 1934 Indian Reorganization Act, Secretary of Interior is authorized to take land into trust within and without Indian reservations by administrative action. And the regulations are at 25 CFR Part 151. And those regulations have led to tribes across the country for decades reassembling their land base by acquiring land, purchasing it in fee, and then having it taken into trust. Once it becomes trust land, it's Indian country, and the tribe can exercise its jurisdiction as a sovereign power over that land, that Indian country. There's always been one problem for Alaska is there was an Alaskan exception. The Fee to Trust regulation said this applies everywhere in the U.S. to all tribes except for Alaska. Alaska Natives sued over that, and they won. And the victory was there's no rational reason for that Alaskan exclusion. So the Department of Interior is engaged in rulemaking for the last year. And in December of 2014, they promulgated a final rule that eliminates the Alaska exception in the Fee to Trust process. And so the door is open, except that it's all in litigation right now with the state of Alaska and others challenging the new rule, which would allow Alaska Native communities, like the Village of Venati, to apply to take into trust all of the land that was considered not trust land, not Indian country, and over which they did not have jurisdiction, and have it essentially reassemble their Indian country and their Indian land. And that rule is in effect except for the stay by the courts, and if the litigation is successful, the Alaska Native people will end up having the second prong of what it means to be a tribe, which is territory. Hawaii the problem is just the opposite. History of Hawaii, of course, is unique. Actually, Native Hawaiians have treaties, but they predate annexation. So for a period from 1810, when the Hawaiian chieftainships of the different islands formed a single unitary monarchy in the Hawaiian Islands, it was a fully independent nation state. If there was a United Nations in the 19th century, Hawaii would have been in the United Nations. The U.S. had ambassadors, other countries sent to the Hawaiian Kingdom. The U.S. had treaties with Hawaii, and these are not like other treaties with American tribes. These are full-on international nation-state treaties that the United States government had with Hawaii. All that ended on January 17th, 1893. That's the day of the bloodless coup in Hawaii, when what was called the Committee of Safety, a group of planners, and there were some military and others, essentially toppled the Hawaiian monarchy. And soon after that, Hawaii was annexed as part of the United States. Congress has been legislating for decades with regard to the Native Hawaiians. Starting in 1920, the Hawaiian Homelands Act was passed, set aside 200,000 acres plus of land in Hawaii that had been the monarchy's land, and then after annexation was acquired by the federal government. And then the federal government was concerned about the condition of Native Hawaiians whose population numbers were drastically diminishing. So they legislated to set aside 200,000+ acres of Hawaiian land. Federal land is now native land administered by the federal government. And then when Hawaii became a state in 1959, the authority of the federal government with regard to administering this land, which essentially created a trust relationship between the United States. 150 statutes were enacted by Congress dealing with Native Hawaiians. And now the state of Hawaii has the authority to deal with that. But they're not recognized, the Native people of Hawaii, as having a formal government-to-government relationship. There is a federal government on one side of the relationship, there isn't a Native Hawaiian government on the other side. And now there is, again, rulemaking perhaps to the rescue. The Department of Interior last year started a process called Advance Notice of Proposed Rulemaking for Procedures for Reinstating a Government-to-Government Relationship with the Native Hawaiian Community. So that's kind of the Department of Interior saying, we're not rulemaking yet, but we're thinking about rulemaking, and if we do, we're going to create a rule that would lead to the reestablishment of a government-to-government relationship between the United States and the Native Hawaiian people, and it would lead to the creation of a Native Hawaiian government with some sort of a constitutional convention and so on. And this process is underway now. It's supported by the administration, and with less than 24 months left in this administration, with a president who is from Hawaii, born and grew up there, then it has, I think, a real chance of creating, for the Native Hawaiian people, the other thing they're missing. They have the land, they don't have the government, and they may well end up with a government within the next 2 years. So.
I'm wondering if anyone wants to comment. You didn't get into California at all, and I understand that's another whole can of worms, but just especially in case any of the students here are from or interested in California, it's my understanding that of the largest number of tribes in California, they're not recognized. They're very small groups. And I don't know if you can comment on the status and the struggle of those folks.
Well, there are, I think, 110 tribes in California, so in terms of numerically, it's the state with by far the largest number of tribes, and most are small. But I think the Hoopa Valley Reservation is maybe the largest reservation in California. A lot are quite small, called rancherias. Termination occurred in California with California tribes. Public Law 280 applies throughout California. But California also has a very large indigenous population, large urban Indian populations through the relocation program in the 60s. So Los Angeles, for example, has a very, very large urban Indian population, the Bay Area as well, through the relocation program. And then, of course, some people are surprised to learn, I think San Diego County has at least 17 reservations, maybe 24. I'm not sure exactly how many. I was talking to a lawyer who does work down there. And they're very small Mission Indian communities throughout Southern California. The Indian Game and Regulatory Act has actually transformed many of those tribes in California because their lands were so small, but they had one thing, location. They were close to the Southern California population base and the Central Valley base in the case of the tribes around Sacramento and so on.
I guess what I was saying though is that there's several hundred others that are not at all recognized, and the Winnemem-Wintu are a very interesting example of that, because they're currently trying to fight against the raising of Shasta Dam, which will take all their remaining sites on McLeod River and substantially affect, I guess, with the Twin Tunnels project, the Bay Area.
I would like to add that rancherias in Southern California do in fact act often as sovereigns. It was a rancheria that caused the case before the Supreme Court about gaming, which eventually ended up, the Congress terrified the fact that maybe the states didn't have jurisdiction over tribal gaming, put forward the National Indian Gaming Act. So in often cases you find that sovereignty inherent there. If you're a terminated tribe, you have to go through an act of Congress. That is which is a huge burden on these terminated tribes, the Coquel tribe, for instance. So there's different rules for different parts of the California Indian population. But they do act as sovereign, and they do now, of course, have many casinos and trust land on which they can build those. They can only build a casino on trust land.
And depending on the political tide, it's much easier to get state recognition than it is to get federal recognition. And there's a large number of state recognized tribes in California.
That's right.
Howie, other than what you talked about with Alaska and Hawaii, you represent Oregon tribes in some capacity, and I'm wondering what kind of cases you see.
Well, for a long, long time, I don't do much anymore. A younger, more energetic lawyer does what I'm about to say, which is the treaty fishing and hunting rights for the Warm Springs tribe. And Elizabeth has an extensive background in that, and that involves enforcing the tribe's 1855 treaty off-reservation hunting and particularly fishing rights. It's kind of a cottage industry. Once you get into that, it occupies lots of lawyers on lots of cases that never end. The fishing rights case for the Oregon, what's called the Columbia River Treaty Tribes. That's Warm Springs and Umatilla in Oregon, and Yakima and Nez Perce in Washington and Idaho. Those are all 4 tribes with treaty fishing rights on the Columbia River. And fishing is really, really important to everybody, to their commercial fishing groups, sport fishing groups, all have had an interest in it. You follow the fish, anadromous fish, salmon, out into the ocean, find out they go all the way to Alaska and are caught in Alaska, they're caught off the coast of British Columbia. All those interest groups come in to bear in the big fights over fish. And same thing in Puget Sound, with the tribes in western Washington have essentially the same treaty language in their 1855 treaties. They were all negotiated and signed around the same time. And the Bolt case, U.S. versus Washington. In Oregon, it's the Bologna case, U.S. versus Oregon. These are continuing jurisdiction cases. Oregon's case started in 1968, ongoing, probably never going to end. U.S. versus Washington, 1971, ongoing, never going to end. It becomes a vehicle to have the federal court oversee continuing enforcement of the treaty and to resolve new and unresolved legal questions about the nature of the treaty right and versus the state authority or even federal authority. So I've done a lot of that.
The jurisdictional areas are problematic as well, because tribes were handed these are your aboriginal territories. But the reality is we always went up to the Columbia River. We always went down to what is now California. We went to all of these different places to harvest fish and camas and everything else, and we never saw these as locations that we would lose access to. But now we're confined to very defined areas. And so what people tend to believe is, well, that's where they have jurisdiction. But there's also cultural oversight, and then there's also access, too. One of the things that the Coquille tribe struggles with constantly is, let's get what we can right now, because we don't know if we're ever going to get an offer like this in the future. And so we'll take what we can get right now without any contemplation of how that impacts the future. So for fishing and hunting, we've never given up our right for fishing and hunting. But now we're managing our own fishing licenses. We're still paying the state to get fishing licenses, but we're the ones issuing the license itself. That could hurt us in the long run by saying, well, you guys are taking control of your fish and wildlife management. Whereas, you know what, we really didn't limit access to these different areas. If we went up to the Coos River or up to the Siuslaw River, we fished. If we had a good day, we made sure that we gave some to the headman that was there. We never had a limit to a location. And so territories, jurisdictions are very confusing when you think about how natives patrolled themselves, how they governed themselves. The government that we have now, tribal councils, is really a reflection of an American government and not necessarily a traditional government. So it's very complicated when you think about jurisdictions.
We have another class coming in, so we'll have to call it quits. Thank you very much for a wonderful discussion.